Welcome to Coast with DLA Piper Employment, where we discuss trends, hot topics, and employment law. I'm your host, Sherelle Glimp from our New York employment team, and today we are joined by Daniel Turinsky, an employment partner in our New York office. So Dan, today we are talking about non-competition agreements, and we know that employers have frequently relied on non-competes in employment agreements to protect investments in intellectual property, talent, and customer relationships, and the list goes on and on. Can you talk to us about the trends that you are seeing and recent changes that you're seeing in the non-compete landscape?
Sure, Cheryl, and it's great to speak with you and be here today. I think there have been some significant changes with respect to the non-compete landscape, both on a national and state level over the last couple of years. I think the most significant trend that employers really need to keep in mind is the efforts by state and local governments and the federal government to restrict or limit the scope of non-competes, which I think has been trending for a while now and is likely to continue in the near future.
If you had to provide some practical tips for employers to consider as they navigate these challenges, what would you say?
On a practical level, I think it's extremely important for employers to recognize where they are doing business and the relevant law that's in effect in the jurisdiction where they are located. For example, various states now prohibit non-compete agreements. New York passed a law that bans non-compete agreements with some exceptions throughout the state that's headed to the governor for her signature. So I think it's very important for employers to keep in mind the jurisdiction where they're operating, the relevant law in that jurisdiction, and the reason for the non-compete that they're entering into, and the relevant scope that they want to cover by those restrictions.
Very helpful, very helpful. We know that we've heard that the FTC, the Federal Trade Commission, has proposed a new rule that's not yet in effect. We also know that there was guidance issued by the General Counsel of the NLRB. Can you talk about some of those rules as well and how they may impact the landscape?
Sure, those rules could potentially be a real sea change for employers in terms of the enforceability of non-competes. Traditionally, non-competes are governed on a state-by-state basis. But the FTC, or Federal Trade Commission, recently proposed a new rule that would effectively ban non-competes throughout the country. That has obviously gotten the attention of the business community, and we don't know what that final rule will look like or whether it in fact will be enacted, and it will almost certainly be subject to challenges. The National Labor Relations Board, General Counsel, also issued a memo which essentially indicates that non-competes constitute an unfair labor practice in the NLRB General Counsel's view, because they would unduly restrict the rights of employees to engage in protected concerted activity. Now, these are the rules that are proposed or floating out there on a national level. But it's important to keep in mind that various states have enacted restrictions on non-competes that employers need to know about. A number of states, I think 11 right now, plus the District of Columbia, have enacted restrictions such as, for example, eliminating or reducing the enforceability of non-competes against workers who don't make a certain amount of money, and creating salary thresholds to enforce non-competes, or creating other restrictions with respect to whether a non-compete can be enforced if they're signed at the commencement of employment or during their employment, and what kind of consideration you need to give to your employees. So I think it's important to keep in mind both what's coming in the future in terms of these FTC rules, but also what's currently been enacted right now in a number of states throughout the country in terms of limiting the scope of non-competes and limiting the potential enforceability of these restrictions.
Dan, I'm sure there is much more that we can say on this topic. This has been incredibly helpful. Thank you so much. So to all of you who are listening, for more information on this topic, please reach out to your DLA contact. Thank you for joining us, and we'll see you for the next episode of Coast to Coast with DLA Piper Employment.